All right, Ms. Letsom.
Miss Letson, if you could turn on
Yes.
camera, please.
Okay.
Let me send you a prompt, Ms. Letsom. That might help.
There she
Okay,
is.
there you are. All right, so ma'am, it is so dark where you are, I can't even see you. Can you turn on a light or come into the light?
Oh, could you see me now?
Barely.
All right, let me try something else. Oh,
Yes, ma'am. We're conducting business. I don't do business in the dark. That ain't the kind of business I do.
okay.
All right, that's much better. All right, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. Joaquima Rolanda Letsom, you're before the court on case 2022 CR 01489 for DUI less safe, count 1, driving under the influence per se, count 2, and failure to yield the right of way, count 3. Mr. Lynch, what is your client plea to the offenses before the court?
Judge, I believe it's a guilty plea to count 2 and then count 3. Um, right, and a no contest plea to count 3.
Okay, so by entering a guilty plea to count 2, count 1 will merge. And by entering a plea of nolo to count 3, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right, factual basis and recommendation, please.
Yes, Your Honor. On June 18th of 2021, officers with the Clayton County Police Department responded to Riverdale Road near Norman Drive in Riverdale, here in Clayton County. There they made contact with Miss Letsom. This is after responding to an accident or during response to an accident with injuries. After medically qualifying her and observing several indicators of intoxication on Miss Letsom's person, the officer conducted HGN, yielding a result of 6 out of 6 clues. The officer did not go into any other standardized field sobriety tests because, due to her neck and back pain, they were concerned that would affect the testing. They did use a portable alco sensor, which led to a positive result for alcohol, and a blood test was taken. The BAC of Miss Letsom was 0.130. Your Honor, the state's recommendation in this case is 12 months to serve 3 days, credited 2 days, balance probated, 240 hours community service, DUI risk reduction, substance abuse evaluation, and any recommended treatment, no drugs or alcohol, a $600 fine. The failure to yield with an accident will be a suspended fine of $100. I believe that there is some. I believe that the state and defense are not in agreement as to the time that was served.
All right.
Served.
So, Judge, it's not that we're not in agreement with, what is reflected. However, from speaking to Ms. and we do appreciate the state recommending the minimum. From speaking to Ms. Letsom, though, she went in on Friday, early in the early morning hours of Friday, didn't get out until Monday. I know this was during COVID, and I think it's possible that she was being processed out, and it took some additional time. I can't speak to that process, but Miss Letsom is adamant that she did spend 72 hours. She does have some medical issues. She deals with asthma, Judge, and the case is barely within that 10-year window, just barely. And so we wanted to ask the court to consider to credit her based on her representation of how much time she actually spent before she was fully released to the street.
All right. Was it said there was a collision?
Yes, Your Honor.
There was an accident, Judge.
Was anybody hurt?
If I may have one moment to confirm, Your Honor, I believe that Miss Letson was the only person injured in the accident.
Okay. So Ms. Letsom, this is a 2nd and 10 DUI, which tells me that you didn't learn the first time. What's going on?
Well, at that time, I just got news that my brother passed away, and I was coming from the Waffle House because I was hungry, and I
They don't
was.
serve alcohol at my Waffle House.
I know. I mean, I wasn't at the Waffle House when I was drinking. I I had a drink at the bar. Went to Waffle House. On my return to my house, I turned and the car smacked me in my rear end, and my car spent out of control.
Okay,
And that's when
let's talk about a couple of things. Okay, so the accident concerns me less than your representation that you had a drink because you tested positive for alcohol. Your blood alcohol was twice the legal limit. Legal limit is 0.08. That after anything that and above is impaired for the purposes of the law. You had a 0.130, which means that you had more than one drink. And so what I don't want us to do is start out this relationship we're about to be in lying to each other. Because as long as you're on my probation, you and I are in a relationship. And what it's going to lead to is I already have concerns because this is your 2nd DUI in 10 years, which means that you didn't learn the first time. And I get that you had issues where you may be bereaved or whatever, but you can drink and stay at home, and this never comes to my attention. But at the time when you drink and decide to get on the road, that's when it comes to me. But what we're not going to do is start out this relationship lying to each other. We're just not going to do that. Because here's the issue. People go their whole lives and never have one DUI. You've had 2 in your lifetime in 10 years. And that means you didn't learn the first time and you didn't acknowledge that you have an alcohol problem. Because this is the second time we're catching you. This is not the second time you've been impaired on the road. I'm not even gonna buy that. That's just not part of what we're gonna talk about. So based on that, when I say somebody has a problem with alcohol, generally what I mean is, here it is, you're appearing before a judge again because of alcohol. You are having to spend money that you didn't intend to spend on the court process because of alcohol. If you have a job, you're missing time from your job. You spent arguably, you say 3 days in jail. Nobody chooses to go to jail. So because of your addiction to alcohol, you went to jail. But now you're trying to tell me you had one drink and we're downplaying it. We're not going to do that. We're not going to do that because it's when you take responsibility that I don't have to worry about you having a 3rd DUI and then getting in trouble by hurting somebody. Until you take responsibility. So I don't care 1 day, 2 days, that really is not the big deal to me. What I need is accountability. I need you to acknowledge and to come to terms with the fact that you're making some choices that you wouldn't ordinarily make because of your addiction to alcohol. Nobody chooses to go to jail that I know of. So I'm going to accept your plea of guilty to count 2. Count 3 will be a no-low plea. Count 1 will merge into count 2. I'll sentence you to 12 months to serve 3 days credit for time served. Like I said, I don't care. It's a couple hours. You're going to do 240 hours of community service. You're going to take a risk reduction course. You're going to pay a fine in the amount of $600. That's just the base fine. You're looking at something closer to $1,000 with the DUI surcharges, because for DUI, the surcharges are enhanced. It's more. A substance abuse evaluation and any treatment that they may order, you're going to take the substance abuse evaluation. That is very important to me. And then if they order you to take treatment, you're going to do that because that is very important to me. And you're to have no alcohol or illicit drugs during the course of your probation. Now they're gonna screen you for randomly for alcohol and illicit substances. I expect the people who have a problem with alcohol are gonna test positive within the first month or two, because you can't stop yourself. Even the threat of going back to jail, which hangs over your head in probation, because I could always end it and sentence you to jail, even that threat doesn't keep you from using alcohol. So it's with that threat, when I know that you could go back to jail and you still drink and test positive, that's when I know I'm confirmed that you have an addiction problem, but I got to get you to deal with that. I don't know who you're looking at. They're not going to be able to help you. Is there somebody that is in the conversation that I don't know about?
No.
Okay. So, if you just think carefully, if you are honest with yourself, you will understand what I'm saying is true. Because these are all things that you wouldn't normally do if you didn't have an addiction to alcohol. Or if you weren't using alcohol. I'll even give you this. If you weren't using alcohol to cover up or mask or make you feel better about certain other situations. So, anything else, Mr. Lynch?
Not at this time, Judge.
All right. Count 3 will run concurrent with count 2. So during those 12 months, as long as you're doing all of the special conditions that the court has ordered, then you don't have to pay the $100 fine. That will be suspended, but it will run concurrent with count 2. So Ms. Letsom, I'm going to put you in the breakout room with Ms. James. Once you finish speaking with her, then you can go ahead and get started on probation. You don't have to come back to this main room. But I do want you to understand, ma'am, that the quickest way to get rearrested is to fail to report for probation. You got to report. And a lot of times when people think they're going to test for alcohol, they don't report. But testing positive, you're more likely to go to jail for not reporting than you are for testing positive. Because I expect you to test positive, because I know that you have a problem with alcohol. All right, so I'm going to put you in the breakout room, speak with Miss James, and get all of your questions answered, okay?
All right.
All right, thank you.